Before this hearing even begins, here's what you need to know. A man is facing multiple charges involving a family dispute, including assault allegations and property destruction. But instead of heading toward a full trial, something unexpected is about to happen in court. The prosecution is offering a deal that could make two serious charges disappear, including a felony. The catch? The defendant claims he doesn't even remember what happened because of substance withdrawal. That leads the judge into one of the most important discussions in criminal court: what a no contest plea actually means and why someone might choose it. Stay with us, because this hearing reveals how quickly a serious case can shift direction inside a courtroom.
Ready to proceed. This is a special appointment case from the Berrien County Circuit Court, well, Berrien County District Court, the Niles office. Title of the case is Richard McKinley Elliott Jr. The Berrien County file number is 2025018558 and has a SM, which is a misdemeanor number. And then it was amended, and I think it had a FY suffix. At any rate, this is Judge Middleton here in St. Joseph County, Michigan. I've been appointed as a visiting judge in this case. We have had some previous pretrials in this matter. What is actually set for this morning is a pre-exam conference. The defendant is here by Zoom. His counsel is here and the prosecutor is here. As I indicated, we had a previous discussion of this matter on March 12th. The people are represented by Courtney O'Malley Septowski and Ryan Wojciech. I didn't get it right, but close. Ryan, say it for me.
Wojciech.
I wasn't too far off.
That's pretty close.
Is present on behalf of the defendant. The defendant had been doing some recovery work and had been in an inpatient treatment program.
Right away, the prosecution reveals that negotiations have already taken place behind the scenes. This is extremely common in criminal cases. What we're seeing here is a plea agreement, where prosecutors offer to drop certain charges in exchange for a guilty or no contest plea to another. In this situation, two much more serious allegations, including a felony assault, could be dismissed. That's a massive reduction in potential consequences. But here's the question. Should someone be allowed to plead if they claim they don't even remember the event? Courts deal with this scenario more often than you might think, especially when intoxication or medication is involved.
I'll defer to you, Ms. O'Malley Septowski. What's our status here today?
Your Honor, I believe that we have a resolution worked out to a misdemeanor plea in count 2, the malicious destruction of property, dismissing count 1 and count 3. The agreement would require that Mr. Elliott participate in a probation where he follows the recommendations of his treating physician, Dr. John Baris. Your Honor, I know the court talked about potentially doing a plea via Zoom and then maybe a sentencing in person. So I didn't know how the court would like to proceed today. Mr. Wojciech and I have discussed it. I think there was quite a bit going on for Mr. Elliott at the time, and I think that he, due to lack of memory, needs to enter a no contest plea. I do not have an objection to that. And we're ready to proceed today if the court wishes to proceed today, or if the court wishes to set this for a formal plea, we're happy to do that as well.
I'm prepared to take the plea, but I think I should come to Niles face to face and do the sentence.
That's all correct, Your Honor. I would have no objection to setting out the sentencing date.
Mr. Elliott, let's talk about this. You got charged in an amended complaint that alleges in count 1 that you assaulted Richard McKinley Elliott Sr., member of your household, your father, I believe. That's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. It also would prohibit you from using or possessing a firearm for 8 years. Prosecutor is agreeing to dismiss that charge as a part of this plea agreement. You are also charged with assault with a dangerous weapon, a shoe. That's commonly known as felonious assault. It's a felony punishable by up to 4 years imprisonment. That matter is also being offered to be dismissed by the prosecutor as part of this plea agreement. So what it leaves is count 2, malicious destruction of property over 200 but less than 1,000. That is a misdemeanor. It's punishable by up to a year in jail and a fine of up to $2,000. Up to $2,000, yes, or 3 times the value of the property. Now
the judge pauses to explain something extremely important: the difference between a guilty plea and a no contest plea. A no contest plea means the defendant is not admitting guilt but also isn't fighting the charge. Legally, it still results in a conviction just like a guilty plea. People often choose this option when they cannot clearly remember what happened, or when there might be civil consequences tied to admitting fault. In other words, it allows the case to move forward without the defendant formally saying, "I did it." Have you ever wondered why courts allow that option?
they indicate you're going to enter a plea to that charge, and the plea would be by no contest. So let's talk about a no contest plea. Apparently, you don't have a clear memory of this because of intoxication, and that is a legitimate and common reason for a no contest plea. I don't admit it, but I also don't deny it. By pleading no contest, you accept that a conviction would enter even as if you had pled guilty or had a trial. Do you understand that?
Yes, Your Honor.
All right. If you plead no contest to the charge, you're going to give up your right to have a trial. There will not be a trial. Do you understand that?
Yes, I do, Your Honor.
If you had a trial, you'd have the right to be represented by an attorney. You've retained an attorney, and that's fine with me. If you could not afford an attorney, Berrien County would appoint an attorney to represent you in this matter. If you had a trial, you'd have the right to take the witness stand and testify in your own behalf. You don't have to. You have a right to tell your side of the story, but you don't have to tell it. And if you don't wish to, the judge or jury cannot hold your silence against you. You have a right to have any of the witnesses, either for you or against you, subpoenaed to come to court so they could be questioned under oath. And you have a right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes, I do, Your Honor.
All right.
What the judge is doing right now is known as advising the defendant of their constitutional rights. Before accepting any plea, courts must ensure the defendant understands exactly what they are giving up, including the right to a trial, the right to confront witnesses, and the right to remain silent. This step might seem routine, but legally it is critical. If a judge fails to properly explain these rights, the entire plea could later be challenged or overturned on appeal.
All right. Now, I have some slight factual basis here. So are you pleading no contest to count 2?
Yes, I am.
What were you drinking?
I was not drinking anything. I was withdrawing from benzodiazepines. I hadn't taken my 20 milligrams of Valium that morning. Well, actually, this occurred in the afternoon, but I hadn't taken it that morning.
All right. Let's talk about the information I have. In the complaint and warrant, sworn to by Officer Klein. I can't tell his first name or her first name.
Dominic, Your Honor.
Dominic. He was dispatched to One Park Court. And your sister called and said there was some dispute. You broke a telephone on the wall and the door, and you kicked the screen door of the and broke the bottom of the screen door. So I'm assuming those items were worth more than $200. A cell phone and a door and a screen door.
That's correct, Your Honor. We would have no objection to the value being between 200 and 1,000.
Now we reach the factual basis portion of the hearing. Even with a no contest plea, the court still needs enough information to confirm that a crime likely occurred. According to the police report, officers responded to a family dispute where property inside the home was damaged, including a phone and door. The estimated value of the damage pushes the case into the misdemeanor category being discussed today. This step ensures the plea is grounded in real evidence rather than simply accepting an agreement blindly.
Thank you. All right, now this is where it gets a little tricky because I'm going to need to schedule this with your administrator. And normally here in Centerville, I would just pick a date on my calendar and schedule it because I like to let the defendant know right at the hearing what the date is. But Mr. Elliott has made every appearance. He's got court-appointed counsel. So I'm going to have to coordinate with my staff and Berrien County staff to find a date and time that fits for you. Now, Mr. Elliott, I don't know you, which is why I'm here. I don't know much about this. I don't know your background. I don't know anything other than what I just said. So I'd like to get more information. I'd like to get a copy of the full police report, any photographs, if there are any. And Mr. Elliott, I'd like to know about the efforts you've been making in your rehab. You've been inpatient, been doing some other things. I want to know the good and the bad. This charge is.
Notice how the judge slows things down here instead of rushing directly to sentencing. That's actually a very thoughtful judicial move. Sentencing decisions can affect someone's life long after the case ends, and the judge wants more information about the defendant's recovery efforts, background, and rehabilitation progress. When addiction or withdrawal is involved, courts often consider treatment progress as part of the sentencing decision. The judge is essentially saying, I want the full picture before deciding what punishment is appropriate.
Punishable by up to a year in jail. It's unlikely that you're going to get a year in jail, but that's the maximum punishment. Does not carry a firearm restriction, and it would not show as an assaultive offense, although I understand there's already something on there which prohibit you from doing a deferral. I also need to get up to speed on what Berrien County does for probations. And then I'd like to hear from the prosecutor, your lawyer, and the complaining witness about what they think is the appropriate sentence. So I'm really unwilling to just shoot from the hip here today. I'm going to come visit you over there. It's been many years since I've been to the courthouse in Niles, but it's probably due for a trip. So I don't have the sentencing date right now, Ms. O'Malley and Mr. Wojcik. I will get with your administrator and we'll find a date. Courtney, what day do you normally do sentences over there?
We do them pretty much Mondays in the morning and Tuesday afternoon sometimes. Really, whatever works with your schedule, Judge. We're here every day, so
We'll
I mean,
just fit a
every
block.
day. Yeah.
It's hard for me to this is gonna take a half a day to drive over there, do the sentence and drive back. So I'll try to block out a half a day of time.
Seems like the afternoons are usually a little more open here.
That's true.
If that helps.
Yes. We do have Wednesday mornings. We have pre-exam docket, so we are a little busier on Wednesday mornings.
Which judge is assigned to Niles right now?
Hosebean?
Okay. Mr. Elliott, did anyone threaten you to get you to plead to the charge that you just did
No, Your Honor.
or promise you anything?
No.
All right. I think your plea was voluntarily, knowingly made, and I'll accept it as a no contest to malicious destruction of property over $200. I'm going to come to Niles and we'll do the sentence there. It won't be by Zoom. You will be required to be there in person. So we'll get a date. We'll provide that to your lawyer and I will see you. Hopefully it will be before the end of March, but let's see what's available.
Your Honor,
All
if I could very briefly, just because I don't get much of an opportunity, I just want to remind Mr. Elliott that he should remain working with his doctor's care. I know the family, his family is very concerned about him, including the victim, complaining witness in this case. They're very concerned about his health, and they want to make sure he's currently coming off of some medication. They want to make sure that his health is safe, and so he needs to follow his doctor's orders and not be using controlled substances.
And I think that's a condition of your bond.
And Your Honor, if I could also just add that it's likely that Mr. Elliott, before the next hearing, will be discharged from his current placement at Centerpoint Recovery. So he is looking at other options and having the help of other family members to for another placement or for another kind of temporary living arrangement. So just wanted to make the court aware that
This moment shifts the focus from punishment to recovery. Both attorneys emphasize the defendant's ongoing treatment and health concerns, which suggests the family, including the victim, may actually be more focused on his recovery than on strict punishment. That dynamic happens frequently in family-related criminal cases. When the victim and defendant are related, courts often balance accountability with rehabilitation. But the judge makes something clear in the next moment. Recovery doesn't remove legal responsibility.
he will likely be leaving there within the next couple of days.
All right. Well, it's a great place to be in an inpatient treatment facility. Problem is when you get out, you gotta get out on wobbly legs and you gotta stay on the path you were on. So Ms. O'Malley reminded you of the bond conditions that are in effect. Do we have the ability to do a testing if I were to come there live? A drug test?
Yes,
Could do an instant test?
yes. Our probation is right on site and they do that all the time.
Very good. It's likely, Mr. Elliott, I'm going to give you a test before I do the sentence on the day I give you. So just keep that in mind. All right, that's a good resource. I wish we had that same ability. All right, thank you all for
Thank
being
you,
here in a
Judge.
timely manner. It took us 17 minutes, but I'm looking forward to coming over there. It's been a while, and I'll meet everybody in person and we'll do this. I'm going to get right on the scheduling of this and we'll see if we can do it before the end.
So here's where this hearing leaves us. The defendant has entered a no contest plea to misdemeanor malicious destruction of property. In exchange, prosecutors have agreed to dismiss 2 more serious charges, including a felony assault allegation. The judge has accepted the plea, but postponed sentencing until he can review additional information about the case and the defendant's treatment progress. That means the final outcome, whether probation, treatment conditions, fines, or even jail time, will be decided at a future in-person hearing in Niles. Cases like this highlight how the justice system often balances accountability, family dynamics, and rehabilitation all at the same time. If you found this case as surprising as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.